All rise. I'm going to put that down. The jury arrived.
Good morning. Please be seated.
The defense restaurant.
Members of the jury, the evidence in the case is now completed. You will hear in a few moments closing arguments from counsel. Because the state bears the burden of proof, the state opens first and closes last. So in this case, you'll first hear from the defense counsel. Attorney Coffey.
Thank you. You have the power to judge the facts and to judge the law. We'll start at the beginning with some of the facts that were presented to you by the government. You heard, as the second witness, technically in this case, FBI agent Phil Christiana. I'm going to talk about some of the things that he said to you. Bill Christiana wanted you to believe that his role in this case was just helping out the drug task force. When I asked him how he became involved in this case, he said the following things. These are quotes from Agent Christiana. They contacted me. Entrepreneur Newton, he said, he is definitely the person I recall discussing our potential assistance with. My investigation was opened at the request of the Attorney General's Drug Task Force. My assistance was requested, and as a result, I opened the matter in order to provide them that assistance. I was requested assistance, and I provided it. It had nothing to do with the Joint Terrorism Task Force. And every member of the Drug Task Force that got up there was asked the same question. Trooper Newton, you called Agent Christiana? Trooper Newton said, I didn't call him, it was with my supervisors. Either Lieutenant Hunter or Lieutenant Mayer. And I asked Lieutenant Hunter if he called the FBI, and he said, no, I didn't call him. And when Mayers was asked if he called the FBI, his answer was, I can assure you that no one from the Drug Task Force contacted the FBI for assistance. Someone's lying to you. Agent Christiana continued to answer questions about what happened after Mr. Paul was arrested. His testimony evolved just like apparently the FBI policy on reporting people evolves. I asked him about reporting his interrogation with Mr. Paul. And there was one, he didn't deny that. And he said, it's safer not to record. He said it was safer for whom not to record. He said he wasn't interested in recording anything. He said he didn't take any notes, but if he did, they were in his file, which he didn't bring. And he said, I didn't think Mr. Paul would like me to take any notes. We didn't ask him that, apparently. And he said about the FBI policy about not recording, there's always exceptions to the rule. That it can happen if you want it to. But you have to go through a very long procedure, apparently, to get authorization to do such a thing. But think about who was in charge of the recordings in this case. And that was Agent John. And where did he get that authorization? From the New Hampshire Attorney General's office, through the drug task force. The Trooper Newton told you that it takes between 5 and 20 minutes to acquire such authorization to do a recording. So between 5 and 20 minutes, they could have gotten an authorization to do the recording. They didn't want to do that. So we could know what was said there. We didn't want to record it. And this investigation went on, if you take it from the 17th of April of last year to the date of Mr. Paul's arrest, which was May 30th of last year, went on for about 6 weeks. So even within 6 weeks, there was never any attempt to get any authorization to record, a consensual recording anyway, of a conversation with Mr. Paul by the FBI. Mr. Christiana sat up there and continued to answer questions, but it wasn't easy. I have two little hound dogs, and last year around this time they both got into a porcupine. And pulling the quills out of their mouth was easier than getting any answers from Agent Christiana. When I asked him about what he wanted from Mr. Paul, he said, basically, I asked Mr. Paul if he wanted to cooperate. I thought he had information that was important to the Joint Terrorism Task Force. But at the beginning of his testimony, he said, this had nothing to do with the Joint Terrorism Task Force. He was just there to help out. Then he said, I didn't ask him if he were a lawyer. He just said it was a possibility that he wasn't a lawyer in his cooperation. And then this person who had nothing to do with his investigation except providing the surveillance equipment offered Mr. Paul a deal. State didn't offer him a deal. Drug task force didn't offer him a deal. The FBI offered him a deal. We told Mr. Paul that I told him that we could help him with the matter he was arrested for, this matter. And I asked him if he asked Mr. Paul to wear a wire into the Keene Activist Center, and then Mr. Christiana, Agent Christiana, stopped answering my questions. Briefest answer. You can take that answer or non-answer for what it's worth. I would suggest that you can take from Agent Christiana's testimony that recording someone is okay when the government does it to convict you of a crime, but when they want to use it as leverage against you and your friends, it doesn't matter if they record your response to that. what do we learn from the Drug Task Force, who extensively, according to Agent Christiana, were involved with people that were conducting this investigation? We learned that at any one time during this investigation, there were 7 to 10 officers, FBI, DTF, Hampshire State Police, Keene Police Department, whoever. There was such a large convoy of cars following Richie DuPont around town that they were afraid to all turn around at one time lest they call attention to themselves. You can arrest someone without a warrant if you think they have committed a felony. And you learn from Detective Baer that no one's ever raised an entrapment defense after 2 sales. And that any officer can arrest anyone when there's a warrant. It doesn't have to be the very, very busy drug task force. They were too busy to arrest Mr. Paul at any moment. And they apparently were following him all around town all the time. And that they lured him away from the Keene Activist Center in order to arrest him. It's hard to get in there with a camera on you if everybody knows you've been arrested. They might wonder what you're doing and what you're asking questions about. And in fact, Mr. Paul wasn't arrested by either the FBI or the Drug Task Force. He was arrested by 2 regular old Keene Police Department officers, Officer Goodchild and Officer McLaughlin. They did the arrest. The other thing we learned from the Drug Task Force officers is that the FBI provided some or all of the funds for the controlled buy. The FBI had nothing to do with this investigation. And in fact, Lieutenant Baer said something to the effect of, he didn't know, he didn't care where the money came from. He wasn't really interested in that. We know that the FBI had total control over the recording equipment. They set it up. One time it was Officer Bishop, or Agent Bishop. The other time it was Phil Christiana. They took the equipment off. They brought it back to their office. They produced the videos you saw. They provided them to the Drug Task Force. And according to Lieutenant Mayers, the FBI made an offer of cooperation. The Drug Task Force did not make an offer of cooperation. And that's because the FBI was in control of this operation from beginning to end. There's no way to know how or why, because no one would admit that anyone contacted the other. There's denial on both sides about who was trying to get who or what was going on here. They made it seem like they just all sort of ran into each other in the Walgreens parking lot and decided to join up together and investigate this case. The only real thing the Drug Task Force provided here was Richard DuPont. He wasn't searched. His body wasn't searched before he headed out on April 17th because the Drug Task Force thought the FBI was doing it. Why would the Drug Task Force and the FBI be searching their confidential informant in their investigation? When his car was searched, the police found they were assured by Richard DuPont was table salt. And maybe it was and maybe it wasn't, but you can't know that because they give it back to him. And it sounds silly, it sounds silly. And I think it was treated that way. The Drug Task Force said something to the lab they were sure was LSD. And guess what? It wasn't. So there's no way to know what they just gave back to Richard DuPont in this case. Rich Paul never said this was LSD. You didn't hear him say it. No one claimed that acid is exclusively LSD. The one thing you know beyond a reasonable doubt about this item here is that it is not illegal. It is not a controlled drug. It's not illegal to sell it. And the state has not proven that beyond a reasonable doubt. Richard DuPont made all his other buys to get out of his charges, and we know that happened for him, or at least he believes it did because no one's talked to him about it for a whole year. But he was paid to do this one. He bid for that. He said, oh, no, I wasn't paid for that. Just take my cell phone minutes for the other one. But yeah, I got money, tax money for this one. As far as he knows, he's free and clear of his heroin charges to go on his merry way and do whatever it is he does. The drug task force didn't even give him his little secret code name, Socrates. Richard DuPont said a lot of things to you, but the real Socrates said, among a million other quotes that you may have heard, to find yourself, think for yourself. And as jurors in this case, you have the power to think for yourselves. And the law can be used as a sword and a shield. And the government wants you to believe that it's using the marijuana law to shield the public from harm, and that the only thing that should matter to you is what you saw in those videos. I want you to think about the law they're using as a sword against Paul. You heard from the lab analysts yesterday. Shane Zeman, who told you that what he tested that the government believed to be LSD was not. You heard from Pat Keogh, who told you the following things about marijuana. Marijuana is a class 1 drug. That's how we know it's a controlled drug. We test for that. That one characteristic of a class 1 drug is that it has no medical application. Yet all over the United States, there are laws that allow marijuana to be prescribed. And, yep, Mr. Keogh qualified that because the federal government doesn't recognize that. And that's true. And the state of New Hampshire does not yet recognize that. But ask yourself whether this law makes sense to you. That on one hand, something has no medical application, yet on the other hand, there are several governments who are allowing it to be medically applied. Does that make sense to you? For a law like that to be used as a sword against Mr. Paul. Mr. Paul is not claiming that he was a dispensary or that he was giving out prescriptions. He was not doing that. We saw the videos. We all saw the videos. They weren't a surprise to Mr. Paul. But what he's asking you to think about is whether it's fair or just to apply that law in this particular case. Because really, who knows what this investigation is about? We don't know. Still, Christiana stopped answering questions. I'll tell you what it's not about. It's not about drugs. Trying to protect people from drugs. It's about piling on these charges, 5 of them, to use as leverage against Mr. Paul to get him to do something else. It's about going up the supply chain. DuPont walked away from his charges. And Rich Paul is sitting in the defendant's chair because he didn't want to wear a camera for the FBI. Apparently, if he had agreed to do that, he wouldn't be sitting there with that video. Again, the government tried to use the drug law in this case not as a shield to protect the public, but as a sword to gain leverage over Mr. Paul. Think about who they brought in to testify in front of you. These people took oaths to tell the truth. And they stuck here. This is what they said. Two quotes I will reiterate to you. My investigation was opened at the request of the Attorney General's Drug Task Force. And on the other side, I can assure you that no one from the GTF contacted the FBI for assistance. Someone's wrong. I don't know who. Just going to give you some instructions. At the end of this case. You should listen to this instruction. The other thing you should know is that you are not required to convict Mr. Paul. Even if the state proves its case beyond a reasonable doubt, the elements of the charges. Now, I would reiterate to you that it's not met its burden in the purported LSD case, beyond a reasonable doubt, was what never spoken by Mr. Paul. But if you feel that your sense of fairness and justice in this case, and the way this case was handled, and the way Mr. Paul was treated, that if you feel it's unjust or unfair to apply the law to him, you can acquit him. Even if you think the state has proven its case beyond a reasonable doubt as to the charges. The judge is going to give you an instruction that's going to say, and it's going to sound confusing, and I'm going to explain it to you. I'm not trying to think that's anybody, but it's confusing to a lot of people. You're going to tell you that if the state has met its burden beyond a reasonable, if the state has not met its burden beyond a reasonable doubt, you must acquit Mr. Paul. They have not met the burden of the elements. If the state has met its burden beyond a reasonable doubt, you should. It's a very subtle difference. You must acquit. If they have not proven their case to you beyond a reasonable doubt, you should. You don't have to acquit, even if they have proven the case beyond a reasonable doubt. In this case, for this man, in these circumstances, the fair and just verdict is not given.
Thank you, Attorney Collins.
Very much for your patience in this trial, ladies and gentlemen. It's a little longer than we thought it would. We appreciate your service. Couple of things. I would say that there's been a red herring, but really there's a school of red herrings in the defense argument. The reason why we should quit this. Before I talk about those things, I want to make it clear that the defense is correct, okay, that you do have the power to acquit the defendant even if you decide the state has met its burden to prove the elements of the charges beyond a reasonable doubt. That is true. If you find it repugnant to your sense of justice, if you feel a conviction would be unfair, you have the power to acquit. That's true. That is inherent in the nature of what you do. Let's first talk about the evidence. With respect to the LSD charge, he's charged with selling something he represented to be LSD. It didn't have to be LSD. Cooper Newton, who worked for years years to the DPF, and Mr. DuPont both explained to you that the street name for acid, for LSD is acid. Acid is LSD. You heard the videos. The defendant never said in the videos, well, by the way, this isn't real acid. You might need more of these, but it's not real acid. No, he said it was acid. And the witnesses told you that acid is LSD on the street. He represented it to be LSD. He called it acid. Acid on the street is LSD. With respect to the sales on each of the dates, April 17, 2012, more than an ounce of marijuana sold by the defendant over by Walgreens to Mr. DuPont. No doubt. You saw that for the video, for all the witnesses, for the lab analyst. Same with the other charges. April 27, 2012, at room 118 at Keene NH. No doubt the defendant sold more than an ounce of marijuana. With respect to the acid charge, no doubt he sold what he represented to be acid, LSD, to same thing for May 16th, right over here, when he picks the defendant up in front of Tony Clamato and kicks him around the block. The defendant sold to DuPont more than an ounce of marijuana for money on that date. No doubt. The evidence is crystal clear. And that he had more than an ounce of marijuana on him on May 30th, 2012 in Keene when he was arrested. That he intended to sell it to DuPont. He didn't get a chance because he was arrested first, but he was going there to sell it, so he intended to sell it. So that the evidence is clear. So in terms of the evidence and the proof, not only is it beyond reasonable doubt, it's beyond any doubt that the defendant committed this crime. This brings us back to the question of should we convict? What's your decision? The defense sounded like there's too much evidence. The argument sounded like there's too much evidence. Too many officers. It's not fair to have so many officers investigating somebody's crime. Somehow it's not fair to get so much evidence against somebody. I guess if there's, you can't argue there's not enough evidence, you argue there's too much evidence. There's too much of a focus on the defendant's crime. Somehow that's just not right. Mentioned that DuPont wasn't searched for pornography drugs for meeting with the FBI. And he explained that he certainly didn't bring drugs, but anybody, I do want you to think for yourself, just as really think for yourself. DuPont's not going to bring drugs to the FBI. So, he didn't bring drugs to the defendant, sold them. The whole thing about medical use of marijuana is another one of those red areas. Because none of that was happening here. This is a guy who's making money selling drugs. That's all there is to it. It's a guy who's making money selling drugs. It has nothing to do with medical use of marijuana. The whole thing about who requested the FBI's assistance, the FBI can investigate without a request. That's a red line. Were they confused about who requested the assistance? Apparently. When he first answered, Christian said, I don't remember. That was his first answer. He said, you think it was you? That was his first answer. Because it doesn't matter This case is about, did the defendant commit the crime of selling marijuana as alleged? Did he commit the crime of possessing marijuana with the intent to sell it? Did he commit the crime of selling something he represented to be LSD, acid? He did. The evidence is overwhelming. How is it repugnant to convict a criminal that has been caught just because you put so much effort into making sure you have enough evidence to convict? How is that repugnant? He did not. Okay.
Members of the jury, the evidence and arguments in the case have been completed. I will now instruct you as to the law that applies in this case. Please don't be concerned, this is not a memory test. I will have copies of my instructions with you during the deliberation. After I'm done, you will retire to decide verdicts in the case. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you will have to understand the definition of the crime with which the defendant is charged, what to consider in deciding whether to believe a particular witness, and how convinced one way or the other you should be before you reach a verdict. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I am about to give you. You should follow the law as I explained it, regardless of any opinion you may have with the law ought to. It is up to you to determine the facts in the case. You must decide to based solely on the evidence presented at trial and the law as I explained it. You should fair and just verdict without prejudice, without fear, and without sympathy. The fact that the defendant has been arrested and charged is not evidence of guilt. The indictment is simply a way of giving the defendant's notice of the charge against him. The indictment is a formal way of accusing the defendant of the crime charged in order to bring him to trial. In your deliberations, you must not consider the defendant's arrest, the indictment, or the fact that the defendant has been brought to trial as evidence of his guilt. The defendant has an absolute right not to take the stand and testify. The fact that the defendant did not testify in this case may not be considered by you in any way in deciding this case. The burden is on the state to prove the defendant's guilt beyond a reasonable doubt. The defendant has no obligation to present any evidence or to prove that he is innocent. The possible punishment the defendant may receive if he returns a guilty verdict should not influence your decision. The duty of imposing sentence to the judge should base your verdict only on the evidence in the law without considering the possible punishment. The appraisal lawyers discuss the facts in the law in their arguments. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. The lawyers state the law differently from the law as I explained it to you, that you must follow my instructions and ignore the statements of the lawyers. The lawyers state the evidence differently from how you recall it, so you should follow your own memory of what the evidence was. During your deliberations, you should consider only evidence presented at trial. The evidence in this case consists of the testimony of the witnesses and the exhibits. You may not guess or speculate about evidence. You may only consider what has been introduced into evidence and the reasonable inferences that can be drawn from the evidence. By reasonable inferences, I mean conclusions with reason and common sense needed to draw from the facts that are proven to your satisfaction. During the trial, the lawyers made objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. By sustaining objections or excluding any evidence, you must not guess as to what the evidence or answer would be. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overrule an objection and allow the witness to answer the question, you are not to give such evidence any special importance as a result of my ruling. When I rule on an objection, I am merely applying the law as is my view. If you believe that I suggested or expressed an opinion as to the facts of my ruling, you should ignore such opinion. The court, in this case, as in all cases, is completely neutral and impartial. It is up to you alone to decide the facts in this case. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based on personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. There is no distinction on the weight to be given either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence, whether it be direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions other than guilt. This means that if, from the circumstantial evidence, it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. However, you do not consider each item of circumstantial evidence in isolation. In determining whether all rational conclusions other than guilt have been excluded, you consider each item of circumstantial evidence in the context of all the other direct and circumstantial evidence. In reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or quantity of evidence that is important. What is important is the quality of the evidence. In deciding whether the state has proven a charge against the defendant beyond a reasonable doubt, you must decide the credibility of the witness. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because the witness is taking notes to tell the truth does not mean that you have to accept the testimony as true. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest you consider a number of factors. Whether the witness appeared to be candid, whether the witness appeared worthy of belief, the appearance and demeanor of the witness, whether the witness had an interest in the outcome of the case, whether the witness had any reason for not telling the truth, whether what the witness said seemed reasonable or plausible, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case, or with prior statements by the witness, and whether the witness had any friendship or animosity towards other people in the case. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examinations of the witness, regardless of the quality of the witness. Consider these factors in deciding the credibility of all witnesses, whether or not they have to be ordinary citizens, experts, or police officers. You can accept all what a witness has said, you can reject all what a witness has said, or you can accept some of it and reject some of it. In short, you should consider the testimony of each witness and give it the weight you think it deserves. During this trial, you heard the testimony of experts. An expert is someone with some specialized knowledge, such as scientific or technical knowledge, that qualifies the expert to give an opinion as to matters that are not common knowledge. The opinion of an expert may assist you in understanding the evidence or in deciding the facts of the case. You are not bound by the opinion of an expert. You are free to ignore the expert's opinion if you find that the reasons given in support of the opinion are not sound, or if you find that other evidence outweighs the opinion. Now, as I said, in deciding whether to believe a witness, you may consider whether the witness made statements before trial which are not consistent with the witness's testimony at trial. Thus, if the witness made a prior inconsistent statement, you may use that statement in deciding whether to believe the witness's trial testimony. Keep in mind that you may use the prior statement only in assessing the witness's credibility. You may not use the prior statement as proof that the facts in the prior statement are true. There are, however, two exceptions to the general rule that prior statements may only be used in assessing witness credibility. The statement made before trial was made by the defendant or by a witness under oath, and you may use that prior statement as proof that the facts in the statement are true. Under our Constitution, all defendants in criminal cases are presumed to be innocent unless proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. The defendant enters his courtroom as an innocent person, and you must consider him to be an innocent person unless and until the state convinces you beyond a reasonable doubt that he is guilty every element of the alleged offense. If, after all the evidence and arguments, you have a reasonable doubt as to the defendant having committed any one or more of the elements of the offense, then you must find him not guilty. A reasonable doubt is just what the word would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based upon reason as remains after consideration of all the evidence the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charge, you must find the defendant not guilty. However, if you find that the state has proved all the elements of the crime charge beyond a reasonable doubt, you should find the defendant guilty. The laws of New Hampshire set forth certain crimes. Each crime has a precise definition of at least two parts or elements, a mental state and an act. In deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his mental state was. For a person to be guilty of a crime, he must have the requisite mental state, and he must have physically acted to do something that is criminal. The word act refers to a physical deed. The word mental state refers to what a person mentally believes is a physical act or harm. The matter of determining a person's mental state is something that you will have to decide. There's often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and all the circumstances based on the evidence presented in the case and decide whether the state has proven that the defendant had a requisite mental state and acted to do something that is criminal. The defendant in this case is charged with 3 counts of the sale of controlled drug marijuana, 1 count of the sale of the substance represented to be the controlled drug LSD, and 1 count of possession with intent to distribute the controlled drug marijuana. You must consider them separately and independently from each other and return a unanimous verdict on them. The first count charges the crime of sale of controlled drug marijuana. The definition of this offense has 4 parts per element. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that on or about April 17, 2012, 1. The defendant unlawfully sold an item to another person. 2. The item sold was a controlled drug marijuana. 3. The marijuana was in a quantity of 1 ounce or more, including any adulterants or dilutants. And 4. The defendant acted knowingly. These are the elements of the crime of the sale of a controlled drug. Certain words in the definition need to be further defined. Sale means barter, exchange, or gift, or an offer to make any of these kinds of transactions. To sell an item includes making the sale acting as a principal, proprietor, agent, servant, or employee. Knowingly means the state must prove that the defendant is aware of the nature of the conduct or the circumstances under which he acted. The state does not have to prove the defendant specifically intended or desired a particular result. But the state must prove that the defendant was aware that his conduct would cause a certain result. The second count charges the crime of sale of controlled drug marijuana also has 4 parts per element. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that on or about April 27, 2012, the defendant unlawfully sold an item to another person. The item sold was a controlled drug marijuana. The marijuana was in a quantity of 1 ounce or more, including any adulterants or dilutants, and the defendant acted knowingly. The third count charges the crime of the sale of controlled drug marijuana, and it also has 4 parts or elements. Thus, the state must prove each element beyond a reasonable doubt. The state must prove that on or about May 16, 2012, the defendant unlawfully sold an item to another person. The item sold was a controlled drug marijuana. The marijuana was in a quantity of 1 ounce or more, including any adulterants or dilutants, and the defendant acted knowingly. The fourth count charges the crime of sale of what was represented to be the controlled drug LSD, lysergic acid AFL. The definition of this offense has 3 parts per element. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that the defendant unlawfully sold an item to another person.
The item sold was represented by the defendant to be the controlled drug LSD, and the defendant acted knowingly. The fifth count charges the crime of possession with intent to distribute the controlled drug marijuana. The definition of this offense has 4 parts or elements. The statement of proof of each element is beyond a reasonable doubt. Thus, the statement proved that 1, the defendant unlawfully possessed an item with the intent to sell the item. 2, the item was controlled drug marijuana. 3, the marijuana was in quantity of 1 ounce or more, including any adulterants or pollutants. And 4, the defendant acted purposely. Certain words in the definition need to be defined. Possession means when a person has an item in his or her custody and exercises dominion or control over it. Purposely means that the statement of proof of the defendant's conscious object was the cause of result, or engaged in conduct that comprises crime. Ladies and gentlemen, this case is important to both the parties, state and defense. In the deliberations, you should follow these instructions which the court has given you. You should not decide the case out of bias or sympathy, but with honesty and understanding. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. Your verdict must be unanimous. It's your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement. If you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced of these erroneous. But do not surrender your honest conviction as to weight or effect of the evidence solely because of the opinion of your fellow jurors, or merely for the purpose of returning verdict. When you have considered and weighed all the evidence, you must make one of the following findings with respect to each of the charges before you. If you have a reasonable doubt as to whether the state will prove any one or more of the elements of the offense charge, you must find the defendant not guilty. On the other hand, if you find that the state has proven all the elements of the offense charge beyond a reasonable doubt, then you should find the defendant guilty. Because only 12 jurors will be deliberating this case, I will now select the alternate testimony. Juror number 8 will be the alternate. Members of the jury, before starting your deliberations, you will select a foreperson. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described. You should make sure that each juror has a full opportunity to present his or her opinion in argument. If any questions concerning the law should arise during your deliberations, the foreperson should write the questions out and hand them to the court officer. The officer will bring them to me and I will respond. You should take as much time as you like. When you have arrived at a verdict, let the court officer know and you will be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. Please bear in mind for your deliberations there can be no communication with anyone other than the deliberating juror, the other deliberating jurors in the case, or the judge. You are not to use your cell phones or smartphones to communicate with anyone, by email, or use the internet. Your verdict in this case must be based solely on the evidence presented at trial and the law decided. Thank you very much. You may retire.
All right. Copies of the instructions for counsel as the copies of the jury. And we'll have to do copies of the
Okay.
All rise.
Jury, Your Honor.
Good afternoon, please be seated.
Take the jury roll. Order the jury, please stand. Mr. Foreman, in case number 2012-0131, charge ID number 659-366C, 367C, 368C, 369C, and 370C, has the jury reached verdicts?
Yes, we have.
Mr. Foreman, in case charge ID number 659-366C, where it is alleged that Richard Paul of Keene, New Hampshire, committed the crime of sale of controlled drug marijuana on or about April 17, 2012. Say you, is the defendant guilty or not guilty?
Guilty.
Say he is guilty, Mr. Foreman? So say you all, ladies and gentlemen of the jury? Case number 659-367C, when the defendant Richard Paul is accused of the crime of sale of controlled drug marijuana on or about April 27, 2012. Say you, Mr. Foreman, is the defendant guilty or not guilty?
Guilty.
You say he is guilty, Mr. Foreman?
Yes.
So say you all, ladies and gentlemen of the jury? In case 659-368C, wherein it is alleged that Richard Paul of Keene committed the crime of sale of a substance represented to be the controlled drug LSD on or about April 27, 2012. Say you, Mr. Foreman, is the defendant guilty or not guilty?
Guilty.
You say he is guilty, Mr. Foreman?
Yes.
So say you all, ladies and gentlemen of the jury?
Yes.
In case 659-369C, where it is alleged that Richard Paul of Keene committed the crime of sale of the controlled drug marijuana on or about May 16, 2012. Say you, Mr. Foreman, is the defendant guilty or not guilty?
Guilty.
You say he is guilty, Mr. Foreman?
Yes.
So say you all, ladies and gentlemen of the jury?
Yes.
In case 659-370C, where it is alleged that Richard Paul of Keene committed the crime of possession of the controlled drug marijuana with intent to sell or dispense on or about May 30th, 2012. Say you, Mr. Foreman, is the defendant guilty or not guilty?
Guilty.
Say he is guilty, Mr. Foreman?
Yes.
So say you all, ladies and gentlemen of the jury?
Yes.
Thank you, Mr. Foreman.
Anything further from the defense?
Yeah, Your Honor.
I forgive you.
Members of the jury, the matter that you discussed with counsel, and I will be down to your excuse, but if you wouldn't mind waiting for a few minutes, I'd like to see you and speak with you before you leave. I'll be down probably in about 5 minutes or so. Thanks.
All rise, please.
Thank you. May be seated.
Your Honor, I think RSA 597 1A Roman 2 requires the defendant to be detained unless the court makes a finding by clear and convincing evidence that is not a risk of flight or danger. If the court wishes to consider that issue, the state would ask to be heard with respect to his record.
On the issue of bail, we have that Mr. Paul is he has been on bail now for a year. He has not had any issues on bail. He's appeared for all court hearings. Anything that he thought he would not be able to do, he would file waivers of appearance in a timely manner for other hearings. He's been in contact with me. He lives locally. He's no reason to believe he's going to leave the area. And there's been no, I know he has a record, but there's been no indication of danger to society or to others as far as any physical danger to anybody. To my knowledge.
Very well.
Thank you, Your Honor. Just for the court's information, with respect to his record, and counsel for the defense can correct me if I read this wrong somehow, but it appears to me he's got a misdemeanor conviction in Michigan, some driving conviction for a license suspended, a retail fraud, second degree conviction in Michigan. Level doesn't appear, but I would say it's probably a misdemeanor. Another driving misdemeanor looks like in Michigan. In New Hampshire, misdemeanor, Class B, possession of controlled drugs. So he's got a couple of those. Obstructing government administration, misdemeanor, 2010. And the contempt of court in 2010 as well. And that's the extent of his record as far as I know.
That is, you heard just one small issue, which is that the charges in Michigan are very old, all occurring before Mr. Paul was 20 years old. And are all misdemeanors, to my knowledge.
As we reviewed the statute and considering the number of charges for which the defendant has now been convicted by a jury involving the sales of marijuana and possession of intent to sell marijuana, I find that the defendant has not met his burden under the statute and needs to be detained from the sentence. Anything further from the state?
No, Your Honor, thank you.
Anything further from the state?
We love you, Rich.
Yeah.
Love you, Rich.
Love you, Rich.
Love you, man. Sorry, man. It's very brave. You didn't do anything wrong, and you know that.
You did a great job, Rich.
Y'all haven't seen the last day.
Only one camera allowed, can't be used another.
It's taking your friend for 81 years.
Bob, stop distracting from this moment, seriously.
You must be
I love you,
tired.
baby.
I love you too.
I am so proud of you. You're a hero.
We love you, Britt.
I love you,
man.
See you
soon.
Love you, man.
I love you, Rich. You ashamed of yourself, John.
Yeah, not a problem.
Awful, man.
It's within his body.
It's his choice.
Did you take
Can't force anybody to
No right.
do anything.
It's not
John, everything you say? Encounter? Good case? Feel good? Bad? What's the joke? I'm not coming to life.
Want to cover all your face? Gary, you got it right here?
Yep.